So do we have Barrister Ereye? Okay, I think it's going to join us, but we just have to proceed now. Well, usually we start with opening remark as the host. I usually give opening remark where I set the course of our engagement before the speaker will come up with various, various content, and we'll ask a lot of questions. This is going to be a practical section, and I want us to please and let's engage. There are some questions that are related to your place of work or your own personal experience. I'd like you to share those experiences with us, those cases with us. So in today's fast evolving workplace, staying compliant with labor laws is not just a legal requirement, but a strategic necessity. All right. In the course of our conversation tonight, you will see some of the rulings of the and judgment of NICN. They even gave one a few days ago, right? And that cut across employment space, right? That actually redefining the boundaries of employers and employee relationship. And it's critical that HR professionals, business owners, and corporate leaders stay ahead of these changes. In this webinar, we are going to we'll be looking at practical some of the latest or current rulings, maybe 2, 3, 4, 5 years back, and how they are shaping the hiring practices, the workplace safety, employees terminations, compensation claims, and other suits. I will also want to see how to translate some of this legal development into practical HR policies and employer obligations that we must implement in our various organizations. The speaker that will be speaking with us tonight, it was on a webinar sometimes back in the year 2021, where he anchored labor and labor law, or labor and labor act. We have the video on YouTube. You can just check it, or we can see share on the platform with you. Very powerful, very sound speaker, and will be, speaking and talking to us on employment law, the importance of importance of NICN, judgments, real life HR case studies, and legal interpretation of it. And I want just to, just want to encourage us that we should keep our mic muted unless we are speaking. Then, as the session will proceed now, please want to beg you to drop your questions, whether the question you have, or you have a comment. We want to really ask you to please help us to drop your comment on the chat box. Also, we also want to tell you that this session is being recorded, and if you like I do, I like to join every webinar with my video on. It keep me engaged and focused. So without further ado, I believe by now our speaker should be on the call. And I would like to introduce our speaker. Please, okay, yes, I've seen our speaker. So just a moment. Just a minute. So let me just do an introduction of our guest speaker before we yield the floor to him. Well, Reoluwa is the principal partner, A.O.&G Associates, a commercial law firm located in the heart of Lagos. Prior to this period, he was formerly the senior associate in Elvira Saleras and Associates, a Nigerian French law firm located in the heart of Lagos State. Reoluwa has over a decade of experience in labor law practice, which he started gathering from Kunle Fadepe and Co. Driven by his bias for labor law, he started lecturing at Chartered Institute of Personnel Management in Ikeja chapter, where he imparts knowledge. He is routinely described as an expert in labor law by the on-air personalities at TV Central, Challenge 42, September 422, a digital terrestrial television station. He is a lawyer to several outsourcing companies like the prestigious ICS Outsourcing and Recall Limited. Rolua is equally a litigator and well known at the National Industrial Courts. He has passion for space for specifically litigating novel areas of law by leveraging the international instruments and applying the Third Alteration Act of 1999 Constitution as amended. Irolua continues to share his thoughts on several online platforms. Join me in welcoming my friend, a very good friend of mine, an excellent legal luminary, a learned personality, and a big, huge fan of Chelsea. You can just do an icon, an emoji just to welcome me to know that it's well welcome. Wonderful. Thank you for that, Temitayo. Thank you for that. Thank you. I can see. Wow, I can see a lot of wow. So, Irolua, over to you, sir.
Okay. Sorry, I'm just trying to. Yeah, thanks so much, Mr. Ebenezer. Out of all the introductions, when you said I'm a huge fan of Chelsea, I can't help but laugh. Don't worry, we are not doing very well right now. We're not doing very well. Anybody that is very close to me will know that I like Chelsea, but now I seldom watch football. Okay, thanks for that introduction. And apologies that I joined late. I've just been fiddling with technical issues. Most of the time when okay, so let me just put on my video. Yeah, thank you. So you know that now in Nigeria, we usually find it very difficult. We're always shouting network problems, especially when MTN has increased their tariff and all the telecommunication operators. Okay, that being said, let me just go straight to the topic. National Industrial Court, current rulings, current judgment, I believe that's the topic and its implications. Now, we may not be able to cover the field because indeed the field is quite large, talking about National Industrial Court. Apologies that I don't have any slides because I've been up and doing. I actually wanted to prepare slides, and I will try as much as possible to even do that after this lecture because we're going to be talking about a lot of things. Like I said, we'll not be able to cover the fields. Okay, so now when we talk about the judgment of the National Industrial Court, there have been several judgments. Now, National Industrial Court is a court that had been in existence since 1976, pursuant to Trade Dispute Act, but the court has been elevated as a Superior Court of Record in 2010, pursuant to Section 254C of the 1999 Constitution as amended. So on that basis, we can just imagine the number of judgments the judges have churned out. Now, let me first advise before delving into this topic that National Industrial Court has a website. And on their website, you can see several judgments. Now, National Industrial Court is located in Lagos, is located in Abuja, it should be located almost in all the states of the Federation, being a federal court. However, there are some states that doesn't have National Industrial Court. I know that Benin doesn't have, so any matter in Benin has to go to Akure. So that's just as an aside. And that to underscore the fact that National Industrial Court has churned out a lot of decisions over time. Now, we need to also understand something. When we talk of the current rulings of the National Industrial Court as they've shaped labor relation, especially employee-employer rights, Mr. Ebenezer, that's the topic, right? Because yes, as a shaped employee-employer rights. Now, we need to understand that there are some principles of law that are immutable, that National Industrial Court will always rest on. There are some principles of law that have changed, that National Industrial Court are churning decisions on, are churning new decisions on. Now, we're going to talk about, I'll try as much as possible to focus on the ones that are immutable so that at least we can remind, we can bring it to our memory that as far as this principle is concerned, National Industrial Court has not taken a reversal. Now, we'll now try as much as possible to also consider some decisions that are now changing. that are now changing, and we'll try as much as possible to now merge it with employer and employee rights. Now, why do I choose to do it like this? Apologies, I'm the captain of this ship, so please allow me to do it this way. Now, why do I choose to do it like this? The reason is because as human resource practitioners, we are usually the first lawyer when it comes to labor matters to our organizations. And whether we like it or not, the success or failure, if an employee is going to institute an action at the National Industrial Court, rests almost weightily, almost at every point in time, on human resource practitioners. So what I'm saying in essence is that if an employee wants to sue, whether the employee is going to win the organization would depend on how smart, and how witty and how proactive a human resource practitioner is. And let me explain that. I don't know whether I've told you of a particular case I handled whereby the human resource practitioner, after he has terminated an employee's employment, now proceeded to now dismiss the employee again because he claimed that the employee failed to accept a final warning letter that leads to termination and that leads to dismissal. Of course, you would understand that that decision by the human resource practitioner was very, very unwise. And it took the grace of God, because I was the one that I represented the defendant in that case, the company where the human resource practitioner worked. And it took the grace of God for me to be able to argue that the court should not award damages against them. Now, I've been on both sides of the divide. I've acted for the employee before, I've acted for the employer before. So I can tell you most of the time the way the court is going to decide. I was still at the National Industrial Court yesterday. Now, the first thing we'll be talking about is the issue of termination. And when we talk of the issue of termination, we'll be talking about if an employee tenders his resignation letter, when does it become effective? And the reason I'm talking about that issue is because sometimes an employee will tender his resignation letter and the employer will say that I'm not accepting the resignation letter. Or the employer will say that the resignation letter was effective on so date. So what is the position of the National Industrial Court on it? Yesufu against Governor of Lagos State. West African Examination Council against Felix Iwarwe Oshonebo. Now, these are cases that are 2013, 2014 cases. And these cases are immutable on the fact that when it comes to the effectiveness, these cases are immutable on the fact that when it comes to the effectiveness of letter of resignation, that a letter of resignation usually becomes effective when it is received by the employer. A letter of resignation does not become effective on the date on it. A letter of resignation does not become effective on whether it is accepted or not. It becomes effective on when it is received. So what I'm trying to say, in essence, is that the effectiveness of letter of resignation, as far as National Industrial Court is concerned, is when you give the person you are supposed to give and the person now accepts it. Now, let's now take the argument further, or the reasoning further, because people want to say that, what if someone fails to accept, what if the HR fails to accept a letter of resignation? Of course, we know that we are in this technological age. We can always forward a letter of resignation to the email of the HR of the company. Now, people would also say that, is it possible for my company to say that they are not accepting a letter of resignation? No, it is not possible. Why is it not possible? Because it is the prerogative of either the employer or the employee at every point in time to resign. A resignation is a type of termination. There are several types of termination. Termination by breach, termination by death, termination by operation of law, termination by performance, termination by agreement. And one of this type of termination is also termination by notice. Resignation falls under termination by notice. So if we look at Section 11 of the Labor Act, we're going to see the appropriate notice that we can give in some circumstances, but this is not even where I'm going. So where I'm going, in essence, is that in the event you give a letter of resignation and the employer is saying that I cannot accept it, the employer cannot say he cannot accept it, because in that situation, it makes the letter of termination, it makes the contract of employment slavish, And a contract of employment is a contract of service and not a contract of slavery. So an employer cannot say that you are giving me a letter, I don't want to accept it for any reason, even if you're under, if they're investigating you and you tender a resignation letter, they will still accept it, because the position of NIC is that nothing must serve as a clog in the will of resignation. It is a contract of service and it is not a contract of slavery. And my position, National Industrial Court have always supported this position with Section 73 of the Labor Act. Section 73 of the Labor Act prohibits forced labor. We also have Convention 29, which is the Forced Labor Convention of 1930. That convention also prohibits forced labor. Now, when it comes to the issue of convention, we need to understand the fact that it is long gone that people will say that National Industrial Court cannot apply convention. National Industrial Court can apply convention. They are seen as international instruments. An ILO convention is seen as a yardstick of parameters through which best practices are being measured. And since Nigeria is a member of ILO, whether the convention has been ratified or has not been ratified, by virtue of Section 254 C and subsection 1F of the Third Arbitration Act of 1999 Constitution, National Industrial Court is enjoined to apply convention, whether ratified or not ratified, as international best practice. So, in all, we need to understand that when it comes to the issue of termination and it comes to the issue of tendering of resignation letter, the employer cannot say that I'm no longer receiving it. Now, another thing I would also want to talk about that people, there have been a lot of debate, is the issue of when an employee resigns. For example, if an employee decides to resign, this principle centers on the issue of this principle centers on a particular decision that Honorable Justice Kanye decided. And what is that decision that Honorable Justice Kanye decided? It says that if an employee has already tendered his resignation letter, now, most of the time, the employer will say that I'm terminating your employment, and the employer will terminate without not giving any reason. The employer will terminate without not giving any reason. Most of the time, if the employer terminates like that without not giving any reason, employee will say that how can you terminate my employment without not giving any reason? And they will go to court. Now, the position of National Industrial Court before was that an employer can terminate an employee's employment for a good reason, for a bad reason, or for no reason at all. However, that position has already changed. The new position now is that if an employer decides to terminate a contract of employment, it's fashionable that the employer will include reason. And that reason will be based on conduct, performance, or operational requirements. Now, Ebere Onyekachi Aloysius against Diamond Bank of Nigeria PLC was a case that Honorable Justice Kanye first applied that principle. And when Honorable Justice Kanye is the president of National Industrial Court now, as at the time, I think that decision was made in 2016. As at the time the decision was made, Honorable Justice Kanye was the admin judge of National Industrial Court. And I, for one, complained, and I said that how can the judge give this decision that if an employer wants to terminate now, the employer can either terminate on conduct, performance, or operational requirements. Honorable Justice Kanye premised that decision on the Termination of Employment Convention, Article 4, Convention 158, Termination of Employment Convention. Now, if we look at the totality of that convention, what the convention does is to protect the employee against unjustified or wrongful termination. But again, we need to understand the fact that the convention does not at any time says that the employer cannot terminate. It only says that the employer must give reason. Peradventure, the employer does not give reason. What the employer would only be liable for is damages. But as at the time that decision was given, this is the litmus test. As at the time the decision was given, there was a time that people normally says that the decision of National Industrial Court cannot be appealed against. In fact, I used to have that mentality, or I used to have that thinking, because I remember doing the matter then in 2013, Gerald Esogo against Zenith Bank. The decision was given against my client, by extension me. I wanted to appeal, but we're thinking that we cannot appeal. Now, currently, People can appeal against the decision of National Industrial Court now by virtue of the principle is in Skybank PLC against Victor and Iwu. But this is not where I'm going. Where I'm going now is that when Justice Kanye gave this decision of Ebere Kacha Aloysius against Diamond Bank that mandate the employer to be given reason, some people appealed, not against that decision, but subsequent cases came up that made people to appeal. And part of the case is Oak Pension Limited against Olayinka. Now, when that principle by Justice Kanye got to the Court of Appeal, the Court of Appeal had to amend what Justice Kanye said as to mandating employer to give or not to give reason. So the Court of Appeal said that if the contract of employment is very clear on the fact that either the employer or the employee can terminate without giving reason, then that contract of employment will supersede over the Termination of Employment Convention, because the contract of employment is the document that regulates the relationship between the parties. Now, that is actually a new principle, because if we look at it, a lot of people, especially HR, are still laboring under the impression that, based on the decision is Aloysius against Diamond Bank, if I want to terminate, I must give you a reason. But now, Oak Pension Limited against Olayinka is to the effect that if in your contract of employment, both parties have agreed on the fact that they can either terminate without not giving reason, then you are covered by that. You are covered as against the principle laid down by Honorable Justice Kanye. So now, what I usually do as a labor law practitioner, and not to allow myself to be caught in the web of Justice Kanye's decision, in the case of Ebere Kacha Aloysius against Diamond Bank, is that any contract of employment I draft, and I'm telling HR practitioners too, any contract of employment you draft, please remember to ensure that you put an obligation to terminate without giving any reason there. That will enable you to terminate without not giving any reason, and that will not make you to be bound by the shackles of Article 4 of the Termination of Employment Convention of 1958. If you don't do that, then they can use the principle in Justice Kanye Ebere Kacha Aloysius against you, that you terminate without not giving reason, and that you should pay damages for wrongful termination. I've done it before. That's why I said I've acted for the employee and I've acted for the employer. If I'm acting for the employee in this case, and my employee comes to meet me that they've terminated his or her employment, the first thing I would do is to say that, let me see the contract of employment. If the contract of employment is bereft of the obligation of either party to give any reason, then I'll be saying that to that extent, the employer has a mandatory duty to give a reason based on the Termination of Employment Convention. I'll be applying that, and I'll be applying Section 254 of the Third Alteration Act that mandate the National Industrial Court to apply international convention as a sort of international best practice. So that's another thing we need to understand. Now, there is now this decision by Honorable Justice Ogwanya. Sorry, I'm just saying it as I'm remembering. Honorable Justice Ogwanya in Abe Adewumi against Equinox International Resources Limited. Now, I'm not sure whether HR practitioners are familiar with the principle in this decision. Now, what does this principle say? Very funny. The practice to human resource practitioners is that if you terminate someone's employment, and let's now say the termination comes at the middle, let's say the termination comes probably 10th of the month, 11th of the month, 12th of the month, the termination occur on or before the end of the month, in which case the employer had already worked some time. Now, what we normally do, even myself, what I used to do is that I would just advise my client that you should prorate the salary. For example, from the 1st of the month to the 10th of the month. And the proration will be based on the principle of quantum merit, which is an equitable principle, as much as something worth. But in the case of Abe Adewumi against Equinox International Resources Limited, Honorable Justice Ogwanya said that if an employee's employment is terminated at the middle of the month, that the employee will be paid salary to the end of the month. And the basis or the ratio of my lord was that that's such a, to the extent that the employee is not the salary is not a fractional payment, so to speak, that the totality of the amount that will be paid must be the full salary for that month and not prorated salary. In that particular case, The employee's employment was terminated at the 15th of September. I remember reading the fact of that case, 15th of September or thereabout, and they paid him prorated basis. In fact, when the employee went to court, the employee was not even seeking that they should pay him the full salary for that month. It was the judge that now dwelt on that case and now said that this person must be paid the full salary for that month because this person is not a daily worker, this person is not a weekly worker, this person is a monthly worker. So to the extent in which this person is a monthly worker, this person is entitled to salary at the end of the month. And to the extent in which this person has worked to the middle of the month, the court said that the total salary should be prorated to the end of the month. So I found the decision very funny. And fortunately, Honorable Justice Ogwanya taught me in law school. He taught me corporate law. So I remember that on one of the trainings I went for, I met him and I challenged him on that decision. And my lord said that we should start revolutionizing the National Industrial Court and the principles. So we can imagine. So for HR practitioners, we must be very careful when terminating. Because for me, that I deal in the labor law space, if I see a case like that, I can just sue and say that given that particular decision, and the decision has not been changed. Funny enough, the decision has not been appealed against. So the decision still remains the extant position of the law. To the extent that if another matter happens at the National Industrial Court, a similar matter, by the principle of judicial precedent, you can cite that matter. And the judge before who wants to make that decision will look at it and can give a decision, in your favor based on that principle. So we should also take note of that. Now, another thing we want to talk about is sexual harassment. Now, the issue we have with sexual harassment is that there are not so much cases on sexual harassment, but the National Industrial Court rules, particularly Order 12, has talked about sexual harassment. So that means that the National Industrial Court has taken judicial notice of sexual harassment. Now, the National Industrial Court has identified some forms of sexual harassment: physical sexual harassment, verbal sexual harassment, non-verbal form of sexual harassment, quid pro quo form of sexual harassment. What is physical form of sexual harassment? Unauthorized touching. Now, what the National Industrial Court did is that the court have even started applying the Sexual Harassment Convention. I don't know whether HR practitioners know that there is a Sexual Harassment Convention 2019. That's Convention 190. That's also another thing. So when you want to talk about possibly sexual harassment in the workplace, or you want to talk about what constitutes sexual harassment, it may also be okay if HR practitioners go through that particular convention. I repeat again, Convention 190, 2019. That is the Sexual Harassment Convention. And funny enough, we also need to understand that Nigeria has ratified this particular convention. So to the extent in which this convention has been ratified, it can be applied at the national court. Don't forget, Section 254C, subsection 1F and H gives National Industrial Court the leeway to apply international conventions that have been ratified. If this international convention have not been ratified, like the Termination of Employment Convention, Section 254C, sub 2, give the National Industrial Court the opportunity to apply unratified international convention as best practice. That was what Honorable Justice Kanye did in Ebere Onyekachi Aloysius against Diamond Bank. Termination of Employment Convention has not been ratified, neither has it been domesticated. But the judge nevertheless applies it as international best practice. Now, whether the judge rightly applies it or wrongly applies it is another different ball game. But all we need to do is to understand whether there is an existence of international convention on a particular topic, on a particular issue, and whether such convention can be applied. So that's basically one of the things we need to understand. So that's for sexual harassment. Now, like I said earlier, cases on sexual harassment is a little bit few. I remember that there is a particular case of Felix Orekomaya whereby a woman was terminated because she was pregnant. Folani Orekomaya. The woman was terminated because she was pregnant, and the court awarded damages against the employer for terminating the woman's employment because she was pregnant. We should not forget that there is a maternity protection in Section 55 of the Labor Act. Maternity protection in Section 55 of the Labor Act. Please, HR practitioners should go and read that particular section. Now, I think section 55 subsection 4 or 5 now stipulates something very important, and it says that in the event an expecting mother probably goes into labor, and the labor now becomes complicated to such an extent that the woman had to extend her leave, that within that period they cannot terminate her employment. That particular provision is there in section 55 of the Labor Act, maternity protection. So those are the things HR practitioner really needs to take cognizance of, because all these things are classified under sexual discrimination. So I've cited the Folani Orekomaya's case. Another case I want to cite is Pastor Mrs. Patricia Yakubu against Financial Reporting Council of Nigeria. In that particular case, the woman was sexually harassed, and it's as a result of the sexual harassment that now led to termination. And the woman sued, and the woman was able to prove sexual harassment. Of course, I don't need to make mention of sexual harassment because of the trending topic now. I don't need to mention the parties involved, but we all understand the parties involved, and we all know the meaning of sexual harassment. So the National Industrial Court doesn't take it funny when a case of sexual harassment is brought before it, especially if the employee alleges that as a result of sexual harassment, his or her employment has been terminated. Of course, we need to understand that by the definition of sexual harassment, it does not only relate to women alone. It is not only women that can be sexually harassed. Of course, men can also be sexually harassed. But the prevalent cases that have gone to court involves women. I've never seen a case that have gone to National Industrial Court whereby the man claimed he has been sexually harassed. Please, if peradventure anybody come in contact with that case, decided at National Industrial Court, please tell me. But the two cases I know is the Folani Oyekomaya's case and Pastor Mrs. Patricia Yakubu against Financial Reporting Council of Nigeria. Even in the case of Pastor Mrs. Patricia Yakubu, the lady that was sexually harassed, it wasn't alleged again because the court has decided. The lady that was sexually harassed was able to prove that his boss forwarded his private part to her, and the lady's employment was terminated. So the court just connect the dots together, because the time the picture was forwarded to the time the lady's employment was terminated was almost the same time. So it was almost contemporaneous or simultaneous. And the court awarded substantial amount of damage against the company. Now, another reason the court awarded damages against that case was that the person the lady claimed, the employee claimed sexually harassed her, was the MD. Now, the allegation was directly against the MD. At the National Industrial Court, the MD didn't come to court to traverse this allegation. It was possibly the HR that came to court to traverse this allegation. So the court didn't believe the evidence of the HR, given the fact that the allegation was not directly against the HR, but against the MD. So these are the things we need to be properly familiar, of. Now, when it comes to the issue of sexual harassment, I would rather advise that in line with Order 12 of the National Industrial Court rules, the HR should implement a sexual harassment policy in the organization that details what can constitute sexual harassment and details what cannot constitute sexual harassment. Now, this policy may be separate, but it must be made known to all the employees in the organization, or these policies can be inserted by reference into the contract of employment of each employee, such that it becomes an obligation between the employer and the employee. The issue of sexual harassment, I will stop there. Another issue we need to also look at is the issue of constructive dismissal. And people don't understand. Now, when we say constructive dismissal, people don't really understand what constructive dismissal means. Now, constructive dismissal is any circumstances that makes the work environment hostile for the employee, such that the circumstances was deliberately created by the employer, and it now makes the working relationship between the employer and the employee impossible or virtually, non-workable. And I'll give you an example. Assuming Mr. Ebenezer is working in Iriolua PLC, and Mr. Ebenezer, by working in Iriolua PLC, has a table and chair that he uses to sit. Now, I've wanted to terminate Mr. Ebenezer's employment, but I don't have a way of telling him. He just came to work one day and he couldn't find his table and chair. I've given it to another person. That in itself can constitute constructive dismissal. assuming Mr. Ebenezer wants to come in, and I said that the security man should not allow Mr. Ebenezer to come in, that could in itself constitute constructive dismissal. Sexual harassment could also constitute constructive dismissal, especially when the employee is saying that as a result of this sexual harassment, I can't go to work again. About 3 weeks ago, a friend called me, coincidentally, she's even in the HR space, and she told me that I can't go to work again. Anytime I go to work, my chest palpitates. And I said, why? She said that each time my boss routinely sexually harasses me, such that I've lost zeal in the work. That can constitute constructive dismissal. Now, in the case of Patrick Obiora Mudilim against UBA, United Bank of Africa, a very interesting case. It was a case that dwelt on constructive dismissal. What happened in that case was that the employer advised the employee to resign. The employer advised the employee to resign. So for HR people that normally say advise to resign, we should not terminate his employment, let's advise him to resign. That is also very dangerous. It can constitute constructive dismissal. Why? I've said that constructive dismissal is involuntary type of termination on the part of the employee. So it is voluntary when the employee voluntarily tenders his resignation letter, isn't it? But if the employer makes the workplace very difficult, or the employer tells the employee that go and resign, and that resignation is not a free will of the employee can sue you for constructive dismissal. So let me tell you, now when it comes to termination of employment, either the employer or the employee can terminate. The employee can terminate by resignation. The employer can terminate by termination, as long as it is in tandem, it is in consonance with what is contained in the contract of employment. But if the employer takes over the type of termination by the employee, and the employer now say, okay, we are going to resign, the employer has no choice than to go and resign. That can be constructive dismissal. And that was exactly what played out in the case of Patrick Obiora Mudilim against United Bank of Africa. In that particular case, UBA advised the employee to go and resign. It was along that line, advised to resign. And what the employee did, he was very crafty when he was drafting his resignation letter to say that, pursuant to your directive that I should tender my resignation letter, pursuant to the management directive that I should tender my resignation letter, I hereby tender my resignation letter. Now, when you look at the first paragraph, pursuant to the management directive, that in itself is a connotation of constructive dismissal. Resignation that should have been a voluntary action of the employee has been taken over by the employer by that particular first paragraph of the letter. So HR practitioners, assuming the management has told you that please advise that employee to resign, and you've told the employee to go and resign, and you see in the first paragraph, pursuant to the management directive or pursuant to the HR instruction, please don't receive the letter. Oh, do not receive it. They are setting you up to sue you for constructive dismissal. That is what lawyers like me can advise employees, that are they not the one that told you to resign? You write it there now. But we are going to rely on that particular paragraph in court. That was what happened in the case of Patrick Obiora Mudilim against UBA. But there are other several types of conduct that may constitute constructive dismissal. Locking the email of the employee, knowing full well that the employee usually logs in the morning, so that the employee cannot log in, can be termed as, or has been termed as, constructive dismissal. Removing the employee from the payroll, such that the HR can no longer pay, has been termed as constructive dismissal. For organizations that they clock in, removing the thumbprint of the employees such that the clocking in machine no longer recognizes the employee's thumbprint has been termed as constructive dismissal. Any action, any conduct by the employer to the employee that connotes that the employer doesn't want to engage the employee again without the employee's consent has been termed as constructive dismissal. So what I will advise, instead of the employer getting involved in this conduct, it will be advisable for the employer to just willingly terminate in line with the provision in the letter of termination. As simple as that. So if there is any need for the employer to now give 1 month notice or pay 1 month salary in lieu in consonance with the letter of termination, the employer should do that. So we need to take cognizance of that. Another case, Olabode Ogunyale against Globalcom. It has been held that you cannot force an employee to register with a PENCOM, with a pension fund administrator. You cannot force an employee to open a salary account with the bank of your choice. It is an unfair labor practice. It is an unfair labor practice. So it is time now to talk about unfair labor practice. I'm sorry, I'm just picking it here and there. So when we talk of unfair labor practice, what we are talking about is general practices or conduct that has been found to be unfair as a result of international instruments. General practices or conduct which, judging it by the parameters of International Labour Organization, does not measure up. That is unfair labor practice. So if, for example, now I can premise a conduct that which is not in alignment with International Labour Organization, I can sue on it based on unfair labor practice. So that's why, if I can even go back, not accepting an employee's resignation is also an unfair labor practice to the extent that it is against Forced Labor Convention 1929. Not allowing an employee to join a trade union can also be an unfair labor practice to the extent in which that practice is against International Labour Organization, freedom of association, and right to collective bargaining. So these are principles in unfair labor practices. So we also need to understand that. So for us to generally understand what comes under the context of unfair labor practice, we need to have a thorough knowledge of international instruments that exist on a particular subject matter. For example, we have Protection of Wages Convention of 1947 that also regulates how wages should be paid. What are the conditions when wages are not paid? At what point can it be said that you've infracted? So all these things can also come under unfair labor practices. All these things can come under unfair labor practices. So let's talk about termination again. And I'm bringing out another angle in termination, which is damages. Now, generally, the National Industrial Court has always held almost at the same time, beginning from Chukwuma against Shell Petroleum Limited to Nigerian Produce Marketing Board against Adewumi, Jimoh Abimbola against Western Nigerian Development Corporation. When it comes to contract of service, the measure of damages is usually very clear. The measure of damages is the amount that you would have earned had it been that your employment is rightfully terminated. What am I trying to say? So what I'm trying to say, in essence, is that if you are claiming that my employment is not terminated in line with the contract of employment, that is what wrongful termination means. Wrongful termination is when you terminate in a manner that is not in consonance with the contract of employment. So let me give an example. Assuming in a contract of employment, you are meant to give 1 month notice as an employer upon terminating, or pay 1 month salary in lieu of notice, and you do neither of this and you just terminate, then that means that you terminate the employment of that employee wrongfully. Now, assuming the employee wants to go to court because of the wrongful termination, the employee cannot say that because my employment is terminated wrongfully, reinstate me to my original position. The law should command, or the court should command the employer to put me back in my position. The employee cannot say that, or even if the employee is requesting for that, the court cannot grant it. And the reason the court cannot grant it is that you can't force a willing employee on an unwilling employer. That principle is still immutable. However, when it comes to the measure of damages to be granted, what the court normally looks out for is that what amount will the employee that has come to court to complain, what amount would he have earned had it been that his employment is terminated rightfully? So had it been that the employer wants to terminate and do everything properly, what amount would he have earned? And of course, in most cases, the employee would have earned the 1 month salary in lieu of notice that the employer should have paid him. So that is the limit of the damage the employee can claim. That has been the law all through. However, the position is changing now. The employee can claim more now, depending on what the employee can prove. Let me repeat myself. Before, the employer cannot pay more than what the employee would have earned if the employee's contract of employment was terminated rightly. And most times, it is usually 1 month salary in lieu of notice. But the position is changing. British Airways against Makanjuola. National Industrial Courts are now handling matters related to defamation. So there are in British Airways against Makanjuola, what happened was termination and at the same time defamation. I'll give you an example. There is an allegation that possibly an employee has stolen, or there is an allegation that possibly an employee has involved in some malpractice. The employer does not investigate that allegation. The employer just publicizes the allegation to all the employees in the organization. The employers now terminate and put the allegation that he has not investigated in the letter of termination. The employee will sue, and the employee will sue more than the amount that he would have rightfully earned, because in addition to that, the image of that particular employee has been smeared. The image has been battered. His image has been tarnished. So we need to understand that the era of the employee being confined to claiming what he would have earned as if being his employment has been rightfully terminated is going gradually. Is gradually going, depending on what the employee can prove. For example, if I want to receive a brief and the employee is saying that my employment was terminated, I will not just base it on claiming 1 month's salary. I would also look at the circumstances surrounding the termination. If the circumstances constitute gross misconduct against the employer, if the circumstances constitute defamation against the employee by the employer, those are the things that will now guide me as to the amount of damages that I can claim. I'm saying this because HR practitioners are here. The topic that we're talking about is, how does these principles regulate employees and employers' rights? So it's not only for us to sensitize ourselves on this principle. It will also be very, very okay if we tell ourselves, how does this principle apply, and how can we claim, or how can we deflect this principle? Is also very important. So when it comes to the issue of defamation, the employee can claim more than what he would have rightfully earned. We also need to understand that. Now, another thing is coming up that National Industrial Court has started looking at, and that is the negligence of the employee in the course of duties. Negligence of employees in the course of duties. I'm sorry, I should have written all these things down, but I'm just saying it. Negligence in the course of duties. Now, what is negligence? An act of carelessness, an act of inadvertence, an act of not performing up to the standard expected from a reasonable man by the employee to the employer that have now caused injury. That is what negligence is. Now, over time, employers don't normally sue employees, but we are seeing instances whereby employers sue employees now. But most of the time, these actions normally comes in terms of counterclaim. For example, employee sues the employer for wrongful termination. Employer now remembers that, okay, in fact, in the course of the transaction that led to wrongful termination, you are also negligent. So the employer can counterclaim for negligence. That is the case I'm doing right now. That I'm currently doing a case like that right now. Unfortunately, I will not be able to tell you, the names of the parties, because the matter is still sub judice. But in that particular case, employee is claiming that his employment was wrongfully terminated. In any case, it was not. But what led to the query and the eventual termination of that employee was a case of negligence, a case of you not doing your work properly, as a result of which the employer now lost money. There is nothing that says that the employer cannot sue the employee. Nothing. Most of the time, it is only the employee that sues because the employer just forgoes. But if the employer decides to sue the employee, it is a contractual relationship. And in a contractual relationship, as long as there is a breach, then either party, that has suffered as a result of the breach will sue. After all, the position of the law is ibi jus ibi remedium. Where there is a wrong, there is a remedy. So if the employer feels that the employer has wronged it, then the employer can also go ahead and sue based on the principle of ubi jus ibi remedium. So I'm just saying that now so that the HR practitioners will not feel that possibly if your employee, performs an act that causes injury to the employer, that such a particular employer cannot sue. No, it is not the case. In fact, in the case of Nigeria Arab Bank against Shuaibu, that was exactly the fact in that case. And I think that case is a 2020-21 case that the Court of Appeal held that although there are corresponding duties between the employer and employee, the employer has a duty to take care of the employee, but it doesn't mean that the employee also doesn't have a duty to use his skills. and perform his conduct to a reasonable standard for the employer. That anything the employee does that injures the employer as a result of the employee's negligence, the employer can go ahead and sue the employee. So that is that on the issue of negligence. That's that on the issue of negligence. So let's talk about the issue of training bonds. Training bonds. Now, the issue of training bond is very important because these are issues that are just coming up now. These are issues that are just coming up now. And I'll give an example. Your employer needs a specialist in a particular field. And as an employee, they find you competent and reliable. So they've sent you to Germany to get that training in the particular field. Now, they were the one that expended their expenses. They incurred expenses, let's say 10 million naira, including everything. All the expenses self-incurred by the employer. Now, in exchange for the knowledge, they now made you to enter into an agreement with them that when you come back, you are going to work for us for 10 years without leaving. That's what training bond is. So you enter into a bond with them that in lieu of this knowledge that I want to go and acquire based on the expenses you want to incur for me, I will stay with you for 10 years. Now you come back and you've only worked for 6 months and you've seen a better place to work because of the knowledge and you want to go. Does it mean you cannot go? That is one of the issues for determination by the National Industrial Court. And the National Industrial Court have said that nothing will serve as a clog in the wheel of termination. Even if it is in an issue of training bond, even in an issue of training bond, the employee can still go. But what the employee will now be liable to do is to pay for the amount that has been expended on the employee. So that's how the National Industrial Court has resolved the issue of training bond. So please, when you are constructing issue of training bond or something, please, you must be careful enough to construct it in such a way that in the event the employee wants to go, in the event the employee wants to resign, it's not that the employee cannot go, but the employee will just ensure that he will pay. So you can now add interest to it. So that's what I will advise employers to do. So if I want to prepare a training bond agreement between an employer and an employee now, in my training bond agreement, I will never put in it as a consideration that because the employer has expended money on the training, then the employee must work for 10 years. Even if I say that the employee must work for 10 years, I will now put a proviso that in the event the employee now wants to go, the employee will need to pay money for this period of 10 years. I can now add interest to it, depending on inflation, depending on commercial rate of money at that particular point. All these things are still practicable, but not to say that the employee cannot go. So that's basically the issue of training bond. Now, let's also talk about the issue of contract in restraint of trade. Contract in restraint of trade. So when we say contract in restraint of trade, what do we mean? Because these are also issues that have generated controversies at the National Industrial Court. So contract in restraint of trade or non-disclosure agreements, they come in different forms. They are just clauses that are inserted in a contract of employment to the effect that after the subsistence of the contract of employment, but within a particular period of time, after the subsistence of the contract of employment, but within a particular period of time, the employee will not work for a competitor or in a particular position, or the employee will not work for a competitor at all. Most of the time, human resource practitioners doesn't even know how to draft these clauses. And these are the things that makes these clauses to fail in court if it is being challenged. Now, we should remember something. Naturally, the court frowns at any clause that seeks to prevent an employee from not working for the employer of his choice. And why is that? Because of Chapter 4, Section 40 of the 1999 Constitution, as amended, that talks about freedom of association. So the court had said several times, Kumulis against Leventis Motors, Nordenfeld against Maxim Nordenfeld, that clauses like that limit the employers the employee can work for, and it is not good. It restricts association. However, the court has now given parameters that a restraining clause can work. So the court will consider the time. For example, you want to restrain an employee from working for a competitor because the employee occupies a very important position. The court will say your restraint after the termination of the contract must not be more than 3 years. So when we talk of the time, the court has also talked about the range of function. An employee that was working as an accountant in organization A, by reason of which that particular employee has knowledge of some particular things, may go ahead and work for a competitor as an human resource practitioner, as long as he is not within the position to use the knowledge he gained from organization A as an accountant as human resource practitioner working for organization B. So the court has also allowed that. The court also look at the geographical location. So if the organization A is in Lagos and employee is working in Lagos, organization A is only situated in Lagos, the court will not allow a restraining clause that will prevent employee A in organization A located in Lagos from not working in employee C, organization C, located in Accra, Ghana, or located in Abuja, because the geographical location is not so closely related that even if the employee uses that particular information, it will injure, organization A. So the 3 parameters when I'm drafting contract in restraint of trade or a restraining clause that I normally look out for is, number 1, geographical location. I'll be mindful. Where are you located? If you are located in Lagos, where does your product get to? Where is it likely that they can use your product? I will limit my restraining clause there. I will look at the time within 3 years. Now, the reason the court even talks about time is that the court normally says that an employer should also be able to improve on his confidential information. A restraining clause usually comes in a bid to protecting confidential information. But the court has said that confidential information in a particular time will not be a confidential information in the next 3 years, in the next 4 years. I'll give you an example. I'm a production manager in Nokia, and I know how they produce 3310. Production of 3310 is no longer a confidential information now because the world has moved beyond 3310. So you cannot restrain me because I know how Nokia produced 3310. You cannot restrain me from working in Samsung because I cannot use the knowledge of Nokia 3310 for production of Samsung Fold 3 or Samsung Fold 4 that we normally have now. So the reason the court usually limits restraining clauses to time is in a bid to also allow the employer that wants his information not to be disclosed from also improving on that information. It is an information that is constantly being improved on that the court will seek to restrain so that they will not use that information to your own detriment. So that's basically on restraining clauses. If anybody has questions, we can ask. I think I've been able to cover the field to a very great extent. Thank you. I appreciate you.
Wow. Very impressive and insightful. This is a very detailed conversation. It's beyond my expectation, as always. I also like the fact where you are ending it, the not competing agreement or constraint in restraint of trade. I have a current case at the moment, and that the employee is telling me that the current place of work requires that he should not join a competing firm within the next 3 years. But this ideal of geographical location now, I think I can use that to get talent from them. Thank you, Olua, as always. So I'm sure we have some questions in the chat box, about 6 questions. Permit me to read them out. Of course, there are a lot of accolades coming for you regarding. Okay, so let me ask. Okay, let's take oral questions before we go to the chat questions. We have Claudius Ishamakinde and up. Please, can you go ahead? Please ask a question.
Okay, good evening, everyone.
Good
Very
evening.
great lecture. Yeah, very quite engaging. Thank you for that lecture. I work in the public sector. Uh, your submissions, I don't know whether they will apply, absolutely in the public sector. I know they can apply, in the private sector. For instance, you said an employer can terminate, employment by giving a reason, good or bad. If you give a bad reason in the termination letter, if an employer in the public sector, will that one stand in court? Will that one, be able to?
Okay, thanks so much, sir. Okay, sir. Okay, so if I may answer, reason need not be positive or negative as long as it is objective. Let me say again, a reason that you are giving for termination, it need not be positive or negative as long as that reason is objective. So we need to now understand how is a reason objective, or when is a reason objective. A reason is objective as long as you can prove it. I'll give you an instance. So someone has been dismissed, because even when we're talking of termination, we need to understand that dismissal is also a type of termination. There can be termination by dismissal. So assuming someone is dismissed, and the law is also very clear that when you are dismissing, you must give a reason. And the need for you to give a reason for dismissing is the punitive implication of dismissal. Dismissal is different from termination. Dismissal carries with it an implication that the employee that had been dismissed has performed gross misconduct. Now, when we look at the meaning of gross misconduct can be defined as any conduct that is grave and weighty in character, capable of undermining the relationship of confidence that the employer has with the employer. So I decide to dismiss someone and I give a reason. What I will ensure is that the reason is provable, the reason is objective, the reason is not malicious, the reason is not given in bad faith, it's not given malafide. As long as I can do that, let the employee go to court. An employee that I dismissed because the employee has stolen, and I put it in that letter of dismissal that pursuant to the allegation that has been proven against you that you've stolen. Of course, that means I would have ensured fair hearing. Fair hearing would mean that I would also have ensured that the employee was given an opportunity to state his own side of the story. Have you not seen instances, sir, that you give employee query that, okay, it's been alleged that you've stolen, blah, 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 and they responded to the query and they said they are sorry. Sorry means you've admitted to the fact that you stole. So if the employer decides to now dismiss the employee based on that and now includes the ground that you stole, can the employee challenge it in court? I can challenge it in court. Will the employee win? So we need to understand this fact very clearly. What we are doing here is not because the employee cannot sue. But if the employee decides to sue, the employer must have a strong case. So I usually advise my client, all the things I'm doing, I'm not saying that the employee, of course, anybody can sue. People sue for frivolous reasons. We've seen frivolous action before, and we've seen reasonable action before. So I will just ensure that given the defense that we've crafted proactively, the employee's suit or action against the employer in court would always be frivolous. That's, I've answered your first question. The second question as to whether it applies in public service. In fact, you public servant, you are the one enjoying most. You enjoy what is called security of tenure, security of job. Now, why do you enjoy security of job? I want to assume because most of the public servants, they are government establishments. So they fall under the category or general classification of statutory employment. Now, if you are working for a private employment, you're under common law employment. So the principle that governs common law employment is different from the principle that governs statutory employment. So if we look at that, there are a lot of cases that are related to that, but NIC has always established the principle that when it comes to statutory employment, they enjoy security of tenure, security of service, and in addition to the fact that they enjoy security of service, if it is being proven that termination was done or dismissal was done without complying with the law that creates that employer, they will be reinstated. Years ago, we all saw the case of a I think Unilag vice chancellor that was dismissed in a manner that is not in consonance with the law that creates University of Lagos, he was reinstated. Why was he reinstated? Because he's a public servant. He's working for the government. So when you're a public servant, all these things apply. They even apply more to your advantage. Now, if we juxtapose the principle between common law employment and statutory employment, one of the fundamental differences between them is that in common law employment, you can ask for reinstatement, which is called restitution in integrum, restore me to my original position. But in statutory employment, you can ask for reinstatement as long as you can prove that what they've done is not in consonance with the law. So if the termination or dismissal is not in consonance with the law, then what we have is unlawful termination that you'll be asking the court to declare null and void. So all these things apply to you and more advantageously, sir. I hope I've answered your question, sir.
Great, thank you. Actually, Relua. So Ishama Kingdale has actually acknowledged that. So we have question 1 on the chat. It says, what is the place of the labor law on employers having contract staff for 2 years or more, so as to bypass statutory payments like pension and other benefits, right?
Okay, so let me quickly answer that. Now, the challenge that we have is that we have an anachronistic labor law. We have an antiquated labor law. Now, unfortunately, there are some amendments that should have been done to the Labor Act. There are some, but those amendments have been proposed since over 2010, and they are still lying on the table of the parliamentarians at the House of Representatives when we have Committee on Labor Law and Productivity. I remember that I was part of the conversation like about 6-7 years ago that we proposed that there are some things that need to be changed in the Labor Act. And part of the things that we propose to be changed is Section 7 of the Labor Act. Now, what does Section 7 of the Labor Act says? Section 7 of the Labor Act, Section 7 of Section 1 of the Labor Act says that if someone is coming into employment, the person must be given contract of employment not later than 3 months. And Section 7 subsection 2 says that if you now want to change or amend the contract, you must amend and make notice of amendment note no more than 1 month. Apart from that, that is the closest section that talks about casualization in the Labor Act. The challenge you're having about casualization is that it has not been properly defined, criminalized in the Labor Act. And we know that as long as something has not been properly defined, it is not a crime. There is no punitive measure for casualization. There is no procedure regulating casualization. That's why we're having that lacuna. And that's why all those things are coming under it. So for the person that asks the question, that casualization for 2 years, casualization for 3 years. Now, casualization is in different forms. There are some forms of casualization that it will be for a contract for a fixed term. They will casualize you for a year. You know, people would understand. They will casualize you for a year, and you know, after that year, your contract's still getting renewed. That in the real sense of it is casualization. Now, what solution is for the solution for this? The solution for this is for, you know, our Labor Act to be amended and robust provisions need to be put therein, you know, to regulate this casualization, to regulate casualization in form of outsourcing or in any other form. I hope I've been able to answer your question, sir.
Thank you, Rere. Thank you. Thank you. I think my network logged me out at some point. So question 2 from the chat, somebody was trying to ask about the place of labor law on employers not having plans for the exit of employees in terms of gratuity, right? Some employees don't know that. Ire, can you still hear me? Ire, can you still hear me?
Sorry, I didn't get that, sir.
Oh, apologies.
Yes, I can hear you now, but you're yes.
Okay, so
Your voice became
somebody wanted to ask about the place of labor law on employers not having plans for the exit of employees in terms of gratuity. All right. Uh, did you get that point?
I get it. So let me quickly answer. Does Labor Act has a plan for exit of employees in terms of gratuity? That's the question, right?
Yes, close to that.
Okay. So now we need to understand there was a regime that we had gratuity regime, but we don't have gratuity regime now. All we have now is pension regime. You understand? So we may need to delve into the Pension Act. There was a time that we have the Pension Act of 2004. Now the current regime now is the Pension Reform Act of 2014. Now, the Pension Reform Act of 2014, of course, by virtue of Section 4, has made provisions for contribution by the employer and employee. Now, this contribution, depending on, I think, the provision of Section 7, whether you've been out of job for 4 months or whether you've clocked 50 years, whichever is earlier, that will now entitle you to claim from it. So that's basically the gratuity. So to even start with, the Labor Act does not expressly make any provision for gratuity. No, it doesn't. Now, if the employer can make provision for gratuity in terms of terminal benefit, we've seen those situations before. Can make provisions for gratuity in terms of terminal benefit. We've seen those provisions, but the Labor Act does not specifically. The Pension Reform Act does, and the area of gratuity is long gone. And the reason is that as at those times that they do gratuity, it was the employers they were deducting, and they use those things to commit fraud. I've done a case before against that typical type of case against Union Bank that we now eventually settled, in favor of that we eventually settled out of court, whereby some monies have been removed. I've done a case against Union Bank before in relation to that we now settled. So all in all, I know that gratuity is not provided for in the Labor Act. What we have is pension now, but depending on the contract of employment, that regulates the parties.
Yes, well said. Of course, just like you mentioned, the regime we have now is a pension where the employers pay minimum of 10% of the employees' salary, while they deduct 8% from salary. Of course, there are some companies that pay more than 10% as part of extra support, while there are also some organizations who still give gratuity, right, as a matter of just extra, but there's no law that support that. So companies okay, just want to support the team. But there's no law, all right, or it's not mandatory as it were. So question number 4. So the person wanted to find out, number 3, wanted to find out that what if the employees refuses to let go of company properties with them? You were trying to cite a case that most of the time at the National Industrial Court, most of the cases we have there is employees who sue their employers. You are trying to say that employers also can sue, all right, the employees. So 2 things I want to actually ask there. This person is asking, what in the event that the employees refuses to, release company property assigned to him while he was working with them before he was fired or resigned or he was dismissed? So I think that's the point the person wanted to find out.
Okay, so that's very simple. When the employment relationship between the parties ceases, it is being expected that the employee is supposed to return the employer's property in his custody. And the reason we usually have this is because at all material times, the property does not belong to the employee, except upon termination, the employer now decides to leave or gift the employee the property. That's when the property belongs to the employee. But during the subsistence of the contract of employment, even after the subsistence of the contract of employment, if there is any property belonging or in the custody of the employer can at any time request for that property. So in this instant case, it was the employment relationship that was keeping both of you together, and the employment relationship has been terminated. So return the property in your custody. The employer has failed to return the property. Options are very open. Number 1, that is stealing. That is stealing, contrary to Section 390 of the Criminal Laws of Lagos State. We can also come under criminal conversion. What does not belong to you, you want to surreptitiously, in an unlawful and criminal way, convert it to yours. We can write petition against such an employee to the police. I've done it before. It was the case of a marketer. They usually give them cars. And the marketer went away. He was not in his beat that was supposed to be selling. They recalled him. He didn't come. So they had to terminate his employment. Upon terminating his employment, they requested for the car. He didn't bring it. He has already stolen the car. That's the implication. Or he wants to convert the car to his own use. We wrote a petition to the police. He brought the car and even used the money to bail himself. So the quickest form in order to retrieve employer's property, I don't know whether I'm talking for the employee now. Please, I'm sorry, but I'm just I'm telling you the way it is. But the quickest form to retrieve employer's property is to use the police. And by using the police, there is a legitimate reason for you to. Because the employment relationship has ended, there is no justification for the continuous retention of that property in the employee's custody. So failure to return it means that you want to steal it. And you know that in law, motive itself, intention itself is a crime. Motive is a crime. Intention to commit a crime in law is a crime. So if you don't return it, as at the time you are being required to return it, you are demonstrating intention to convert it to your personal use, and that's a crime. Even on the basis of that intention, the police can arrest and prosecute you.
Well said. You were sounding as if you were in a law court. Maybe you are defending the employer, and that employee must be prosecuted. But thank God you later record that whether you are speaking for the employees or employer. But that's a very valid point. Right. Some people after the employment comes to an end, the tools assigned to them, a laptop, a phone, just to do the normal thing, they begin to rationalize and try to just to get the property of the company to them. We are meant to return the property to, and that will make me to say that this session is not just for HR, right? It's cut across for even the employees, right? They need to know what is obtainable in a workplace, right? So another question for you, sir, right? The person wanted to find out that what if the issue has been investigated and the employee was found guilty? Can publication be done to all employees to caution others? This person, I guess, he wanted to find out when you were saying that when you mentioned that there's difference between termination and dismissal. That in case of termination, you can put a clause in your contract that you can terminate at will, but when it's coming to dismissal, that you must indicate reasons. And probably the person has been found, the person stole company property and it was already established, right? Can you inform the stakeholders, or probably can you inform the employee so that it can be a kind of warning to other persons that if you try to do that, you may be
So in summary, what the person is trying to ask for is the principle relating to disclaimer. Disclaimer. That's what I just summed it up. Now, when it comes to disclaimer, as long as investigation, so let me repeat myself, as long as investigation has revealed that truly the person commits the action. When we talk of investigation now, let's go a little bit deeper. There's no investigation you do without not letting the person involved defend himself or herself, or present evidence in his defense, or call people in his defense. In law, there is a principle that we call audiotarem partem. Here, the other side. That's one of the principles of natural justice. It's even contained in Chapter 4, Section 36 of the 1999 Constitution as amended. That principle must first be followed. You cannot make an allegation against someone and not allow the person to defend himself. If investigation has found the person culpable, I wouldn't want to use guilty, because investigation by the company is different from investigation by the police and conviction by the court. I'm still going to that. Now, if investigation has found the person culpable at work, at least investigation indicts the person. Let me put it in that way. You can publish a disclaimer But I usually advise, even in publishing a disclaimer, let's be very cautious. And I'll say my reasons for being cautious. It depends on the amount of evidence you have against the employee. If the evidence is not indicting enough to show that the employee actually stole, you can just send a disclaimer to say that this also person is no longer working for us or is no longer working with us. You can also put such a disclaimer in the newspaper. I will tell you a case I did in 2014. Very funny case, but very, very funny, but it taught me a lesson. In that case, we acted for a woman that operated a blood designated bank in Lagos State. As at then, there are 7 blood designated banks. You want to buy blood, they will go there. So this woman terminated one of his employees' employment, but she failed to collect his ID card. And she also failed to put up a disclaimer, at least to the extent that this person is no longer working with her or with the company. Now, because this person still possessed in his custody the company's ID card to show that he was still working there, the person used the ID card and the person was collecting blood illegally from underage of 14, 15, 16, giving them as at then 500 naira, 1,000. The person did it and 2 people died. When police arrested him, they saw in his possession ID card of that woman. They came to arrest that woman, and in fact, we got to the commissioner of police before the case can be settled, because they arrested that woman, and they thought it was a matter of conspiracy between the woman and the employee who was doing or who did these nefarious activities. So that to tell you that disclaimer is very important, especially in some sensitive positions. But for me, disclaimer should just be to the extent that we are no longer working with this person again. Just disclaimer simpliciter. There is no need for you to publish the reason for the disclaimer. Now, the law does not say that when you disclaim, that is when you say that this person is no longer working for me, the law doesn't say that you must put reason. What the law says is that if you dismiss, you put reason. Dismissal is different from disclaimer. A dismissal is different from disclaimer. Had it been the law had not make it important to put a reason or a ground for dismissal, I would have said that there is no need to put a ground or a reason for dismissal. There is no need. So putting a reason for dismissal by the employer is in tandem with the law and in a bit to also protect the employer too, so that in case the employee wants to sue. Now, beyond this, there was something I wanted to say that I forgot. The principle of legitimate expectation and detrimental reliance. How does that principle work? HR has given someone a letter of employment. Come and start today or come and start tomorrow. For a reason best known to the management, they did not call the person back, but the person has already signed the letter of employment. They did not call the person back. The person called, please, when can I come and start? They didn't say anything. In that situation, the employer can be liable. In that situation, the employer can be liable. What the employee would just do is to wait for some time, for like 6 months, 7 months, and go to court and sue for the accumulation of salary within that period, based on the fact that the contract of employment has constituted a legitimate expectation that I will be employed. I detrimentally relied on that contract of employment and I was not employed. I've done it before. Against which company? Ikoyi. Is it Ikoyi Hotels or something? It was Ikoyi Hotels. I'll give you the fact of the case. I think it was Ikoyi Hotels or Ikoyi Club. I think it was Ikoyi Club. I'll give you the fact of the case. Now, the company wanted to engage my client He went for medical tests. The test showed that he had hepatitis B, but he went for further tests, and further tests showed that the viral load the viral load was insignificant. Of course, we know that hepatitis is a viral disease. The viral load was insignificant. So the doctor advised him to resume. They didn't allow. He was recruited in January. He had already finished the test by February. The doctor's report had already come in by February. Resume. They didn't answer him. By September or thereabouts, we wrote to them that by not allowing him to resume, it is your duty to provide work for him. By virtue of Section 17 of the Labour Act, you fail to provide work for him. He has already signed a contract of employment. What is important in the contract of employment is offer and acceptance, no resumption. So you are bound to pay him the salary for this period, because it was as a result of your doing that you refused to put him in employment and to work. More so, it is even your duty pursuant to Section 17 of the Labour Act to engage him. And they paid. In fact, they didn't even allow us to go to court. They looked at the letter and they paid. Now, if we look at the case of Ahmed Ishola Akonde against Lily Gates, that was exactly what played out. You engage someone, the person has signed a contract, you didn't allow the person to resume. Once person has signed a contract that signifies acceptance, the contract is valid and binding. It is no longer an offer of employment. The acceptance has translated or transcended the offer into a contract. And a contract is an agreement between the parties that create a mutual obligation and that enables either of the parties to enforce it. So if I've signed a contract and you didn't allow me to resume, and I wait for 1 year, I will say I didn't get another job. I will sue you for my salary for 1 year. I just wish I should talk about that. Thank you.
Well noted. I think that's very, very, very good. Assuming we have more time, we'll have taken 1 or 2 questions regarding the edge matters in the workplace. I had some 2 cases, 1 this year and 2 last year regarding that. But then our time has passed spent. I don't know whether you can take 1 question before we.
No, go ahead. I can. Please go ahead.
Okay, thank you. Okay, thank you. Question number 5, very instructive. What is the place of NICN on salary deductions for lateness, negligence on walkthroughs, etc.?
Okay, thank you. Now, there is what is called, there's a difference between deduction of salary and reduction of salary. Now, let's look at the provision of Section 5 of the Labour Act. What does it say about deduction? Deduction means you remove a specific percentage from someone's salary. The 2 conditions, legitimate conditions, that is allowed under the Labour Act, Section 5, for deduction. Number 1, when you deduct for payment of pension. Number 2, when you deduct for payment of check-off dues. And we know that check-off dues is trade union dues. And we know that for check-off dues, you may consent out of it in writing. That's a provision of, I think, Section 5 of Section 2B or thereabout. It's there, very clear. So these are the 2 legitimate provisions. However, if or in an instance whereby they want to deduct for lateness, they want to deduct for negligence, I will usually advise my clients that envisage instances where you can deduct and put it in the employee handbook. Everybody understands, or we should understand, that the employee handbook constitutes implied contract between the employer and the employee, while the contract of employment constitutes express contract. Implied contract is implied contract by conduct. So if an employer gives you an employee handbook, employee handbook is not personal. Contract of employment is personal. Employee handbook is general. So they serve it round. It is implied that to the extent in which you've seen it, you're expected to comply with it. It can even be what is called intranet, within an organization. So just click it and download it and look at it. So these instances whereby they can deduct your salary will be put there. So that, and before they deduct your salary, deduction is not just done by just deducting. You also write to the employee to tell the employee that this is what you've done. This is the contractual document that regulates what you've done. And this is the punitive measure that is contained in the contractual document, so that the deduction can be very open. It will not be shrouded in secrecy. Because we also need to understand that there are instances whereby deductions are done and the deductions appears punitive. Deductions are not to be done punitively. And deduction should also not be done surreptitiously in a secretive manner, so that the employee will be thinking that, why is my salary being deducted? Now, but there is what is called reduction. Reduction is you are supposed to pay someone 90,000. You now pay the person 50,000 without justification. You reduce the person's salary. So that's why I said there is a difference between deduction and reduction. So I hope I've answered the person's question. So the only instance allowed is Section 5 of the Labor Act in the instance of payment of tax, in the instance of payment of pension, in the instance of payment of check-off dues. However, there are some other instances that can be inserted in the employer handbook, but please, let's document it so that it can align with international best practice. Let's also remember that we have Protection of Wages Convention. Let's also remember that's Convention 84 of 1947. Don't let us forget that. Thank you.
Wow. Thank you so much, Mr. Ere, as usual. I can imagine that you just came in from work and you just sat on your desk, and since around 8.
My brother, I'm so sorry. That's what I didn't prepare any PowerPoint. I'm so
this is more
sorry.
than PowerPoint. This is more than PowerPoint. I must confess.
Apologies.
It would be very good for us to eat the meat than this, but the esophagus is not allowing us to just enjoy the chain of the meal. I would want to sincerely appreciate you for your time this evening. As usual, you're a man that delivers values. During the course of the day, when we send the advert out, somebody reached out to me that said, please, you must remind me that lawyer actually happened to be a lecturer during our CIPM class, and I must confess that you're a man that is well loved, and on behalf of my HR 45, we want to present this award to you, certificate of appreciation. This certificate is awarded to Eroluwa Oguntuashe for your invaluable contributions as a guest speaker at the 45-minute with my HR webinar on the topic HR and the law. Remember, even when you came the last time, it was the Labor and the Labor Act, very amazing section. And I can tell you, tomorrow you release this on YouTube, people will really want to watch. So how the NICN judgment are redefining employee rights and employee obligations today, Wednesday, March 26, 2025. I want to appreciate you. I want to celebrate you. Thank you for the impact you are making in the workplace. Thank you for great and amazing things you are doing in the workplace. We do not take it for granted. We love you and we celebrate you. And on behalf of everyone on the call, we want to say thank you. In case you want to just drop an appreciation chat or message for him, please let's go ahead. Sir, in case you want to share your handles or your social media handles, please go ahead and drop it. It's well accessible. Is the principal partner of a left firm, and you can see it's available to take your job. Probably you want him to represent you, be an employee, or you are an employer, a corporate person. Please feel free. He's going to drop his handles and contact on the platform. Please engage him, and it's well available. Of course, you could see from this section, there was no slide, but look at the way and manner it was dishing things out, stop out, make a reference. This is indeed, a learned person, right? Once again, thank you sincerely, Mr. Ere Oluwa, my good Chelsea fan.
Okay. I'm not going to comment on the last one because we are not doing well. I also want to appreciate you, Mr. Ebenezer. It's a great thing that you're doing. And I would also want to appreciate everybody that has listened to me. I know it takes a great deal, for you to come and stand. I know you have a lot of things that you're doing, but we've all been able to take out time out of no time in order to have this session. So for me, it's not a matter of me delivering. I think I'm also learning because I learned from that. There are some things that you said I've also learned from you. So I learned through questions, I learned through corrections, I learned through opinions too. I learned through opinions and I learned through experiences. So I think it's a quid pro quo. Is a quid pro quo obligation, something for something. So it's a symbiotic relationship. And I also want to appreciate everybody that have been able to listen to this session. It doesn't end there. Let's keep the conversation going. I'm also learning myself. I'm equally going for trainings. I have mentors in form of judges. I know that if my judges are my mentors. I know that if my Lord is watching this, Honorable Justice Esoe, he will say, good, that's my boy. Of the National Industrial Court, Honorable Justice Ogumaya, I take them as mentors too. So we're all learning. And I think in this life, we learn, till we leave the earth. So, but one very important thing is we should not stop learning. We should keep aspiring to know, and we should keep aspiring to also apply to, not only to know, because there is no benefit in brilliancy when we don't apply knowledge. Intelligence is the practical application of brilliancy. So when you are brilliant but you are not applying it, then you are not making impact. So for all the things that we've learned here, that we've heard, we can also research on it, add values, and let's add it to our organization. So that's the purpose of what we've done here. Mr. Ebenezer, God bless you. You're doing a yeoman's job. Thumbs up for you, sir. And for everybody that has attended this, I do my heart for everybody. Thank you.
Thank you, and thank you as always, Barrister Lawyer Ire. Thank you for the contribution you are making in the labor space or in the industrial space. Of course, you are a labor lawyer where you dissect different forms of this. And of course, from our conversation today, I know I have a lot of information to reach out to you, some client because there are some practical things we talked about today that even me myself, I never knew that in fact, I'm going to really gain a lot from this section. And thank you. Please, we are still expecting to drop your handles on the group chats. Please help us to drop your handles so that our guys can reach out to you. Then also we have a friend of the house, one of our team members who is into travel and tour. So say we should tell you that in case you want to travel out of the show, we are wishing you a White House invitation. We are wishing you European invitation. So in case you want to travel out of the shop, and they will give you a discount in the visa assistance to Canada.
Oh, really? Okay. So let's see after this program to talk about that.
Yes. So for everybody on the call, their name is Purple Global Purple Global Travel Services, right? Thank you once again for everybody who spent almost 2 hours with us. I'm telling you, it's a sacrifice for us to go to our various work and come back in the evening by 8 and glue to our screen just to, improve just to learn on what will make our workplace, to be a great one. I want to sincerely appreciate all of us that, joined the call tonight. Some people were asking on the platform that I hope this recording will be available. Of course, yes, we're going to share on all our platform tomorrow. And the way you receive the invite, I'm going to share to across to you guys tomorrow by the grace of God. Once again, I want to say a very big thank you to Mr. Ire. While we are expecting to drop your handles, we must drop your contact. You must drop your contact on the chat, Mr. Ire. Please, I want you to just unmute your mic and just say a very good thank you to Mr. Ire. If you have gotten one or two, information and knowledge from this meeting tonight. Please feel free to unmute and speak.
Barrister Ire, well done, great one. Thank you, very episodic. Please don't forget to drop your contacts. We may not need to consult you. Thank you. Well done.
Okay, thank you.
Welcome, sir. Thank you. I appreciate everybody too. Thank you.
Thank you so much, Barrister Ire.
Yeah, thank you.
God
I
bless
appreciate you, ma'am. I appreciate you. Thank you.
Great. So, Barrister Ire has dropped his phone number. Please, you can reach out to him on WhatsApp, normal call. He's a busy man, but I can tell you that if he's not picking your call, just reach out to me. I will ensure that they pick your call by all means.
Sorry, if I don't pick, probably because I'm in court, just add me on WhatsApp. The first number is my WhatsApp number. Send me a message. Just introduce yourself. Tell me where we met. Then I will just pick it up from there. We don't even need to see physically. Send your documents. I will interpret it. And if there is a need for me to charge you, don't worry. There's going to be a discount. Like the guy doing travels and tours that said it's going to be there's always going to be a discount. But of course, there are a lot of things I can do pro bono. But if there is any compelling need for me to charge, of course, it's going to be mutually beneficial. Don't worry.
Thank you. Thank you. Thank you. With this, we have come to the end of tonight's section. Let's keep in learning. The summary of what Mr. Ire said at the conclusion of the session tonight is that he has to mentor, he's still learning, and also he is, of course, that's why we call them learning. Somebody has corrected me that I should not be saying learning colleague, that because I am not part of the.
You're not a lawyer.
Yeah, I'm not a lawyer. I'm not in the chamber. I should not. I can be sued. So please, so learned words. So how should I address you guys now? The learned fellows or learned?
Just say lawyer. Just say lawyer.
Okay. All right. Thank you so much. We have,
You're welcome.
Paul has been engaging. Paul, you will say thank you for your contributions. Mr. Chris, Mr. Samuel, I think Mr. Samuel Obaka is a lawyer too. Is a lawyer and probably just join to just see what we are doing. Redmayne, thank you to everyone. Lord, just thank you for the moment we spent together. The recording will be shared with us tomorrow. I'll have a very wonderful night to rest for everybody.
Thank you, everybody, and I wish all a restful night. Thank you.